Hello and welcome again to Latter Daily Digest. I have got with me special guest Kolby, who we've had on before, and Kolby's really great to come on for topics like we have today when it comes to legal issues with the church. So we are going to go over the California tithing class action lawsuit and mainly just we're going to go over the nine, main complaints, and Kolby can clarify the wording if I mess anything up here. Anyway, we're going to go over the main complaints of that, what they mean. Kolby's going to explain them to people like me, lay people who may not understand the implications behind what these complaints are, and what they mean for the church, and also what they mean for those who may end up joining the lawsuit. Kolby, do you want to go ahead and introduce yourself and where your legal expertise comes from?
Sure. So my name's Kolby Reddish. I am an attorney that practices law in Boise, Idaho. And I also teach law in the evenings and have for the past several years. I have worked in the past as a law clerk, which means you work for a judge. The way I've explained it to people when I would tell people like at my ward or extended family that don't have any legal background, I tell them I was a law clerk. They thought that I was like picking up a judge's like coffee or something. And I had to explain like, no, what a law clerk basically does is, how you go to the dentist and the hygienist does most of the work and the dentist comes in at the last second and says, okay, everything looks good. It's like, that's what a law clerk is. They're the hygienists of the legal field.
That's a great analogy.
I started my
understand. Yeah,
career,
perfect.
Yeah. I started my career as a law clerk and just had a great opportunity there working with a justice here in Idaho and a lifelong mentor friend. Love him so much. After that, I actually was a criminal prosecutor for about a year. So I tried criminal cases, and in that year, I tried double digit trials in front of juries. So I have experience with that and enjoyed that work for the most part. Then I went in and represented the state for several years, working for our state's attorney general's office. Obviously, my opinions that I'm going to share today are only my own opinions. And now I've entered private practice, but kind of have a weird niche specialty in like weird local government, municipal law, big state constitutional questions. In fact, just last year, I had the chance to argue 2 cases in front of the Idaho Supreme Court, which is a really cool opportunity for me, since that's where my first legal experiences really came from, was working as a clerk in that building. So it felt like returning home, but like in a completely different context. Like you're not a kid anymore. You're like, someone who's there to do stuff. And that was a great experience, really fun.
Nice. Well, thank you so much for joining us today. I'm going to pull up what the main complaints are on screen here. And shall we just dive right in?
Yeah. Before I kind of explain, claim by claim, what the complaint is articulating, I think it might be good if I give just like a high level overview of the civil litigation process. So, everyone's familiar with the fact that cases ultimately usually proceed to trial. Like we understand kind of just generally that that's where a case will progress to. But the way a case starts is with the plaintiff, who's just the side that's articulating the claims. They start by filing a complaint. And so a complaint is a document that puts together allegations and sometimes evidence that will be attached to the complaint that is articulating all of the claims that they have against the defendant, which is the side that will be defending the lawsuit. And so when I use the word claim, what I mean is that there are different legal theories or different things you can use to sue someone and hold them accountable, whether it be a statute or something under the common law. Those are things that you use to hold that person accountable for some wrong that they've done to you or someone else. And so that's the idea behind a complaint, is that it's the plaintiff basically putting everything that they believe happened, their allegations, and trying to make sure that they can check the boxes for these different claims. Now, the way I've explained claims in the past so that people understand them is that claims, whether they, again, come from a statute or come from the common law, they have the best way to think about them is like a recipe. So different claims are going to have different recipes that the plaintiff is going to have to show that that claim is proven. So I'll just use an example. Can you pull that thing up again? Okay, so I'll start with number 4, just because it's an easy one to kind of get the concepts down. So negligence, not in this context, but just generally, negligence is established by the plaintiff proving 4 different elements, okay, or 4 different parts of this claim. They're going to have to prove that the defendant acted, that the defendant in their action breached a duty that was owed to the plaintiff, that the defendant caused damage, like actually caused the harm that the plaintiff suffered, and then damages, which is the actual amount of damage that the person suffered. That's the real high level overview of what a negligence claim means. And so that's kind of to bring home this analogy of like a recipe. If I'm representing the plaintiff in this lawsuit, I'm going to be putting all the facts in there that I think establish that recipe is satisfied here, that I can establish those 4 different elements: act, duty, breach, causation, damage. Those are the things that you're going to try and articulate. And so if we walk through basically this class action complaint, this class action complaint has 9 different claims. So that means that there are 9 different theories that the plaintiffs are going to try and recover from the church on. The underlying substance of the lawsuit, from my brief review of the complaint, is very similar to James Huntsman's tithing lawsuit. So for people who want like a more in-depth dive on that, when the Ninth Circuit Court of Appeals reversed the trial court's dismissal of that lawsuit, Radio Free Mormon, Rebecca Biblioteca, and I walked through that, I think, on the Mormon Stories YouTube channel. So if anyone's interested in that, maybe we can add that link to the show notes, Maven, because it does go into more depth on what statements exactly are at issue that the church had made through President Hinckley and through other church officials. I think that's probably can be a good companion piece if people want to look back here. But so looking at this class action complaint, we have these 9 different theories. We have fraudulent misrepresentation, fraudulent concealment, negligent misrepresentation, negligence, breach of fiduciary duty, unjust enrichment. Then we have, I don't practice in California, but it looks like we have 2 different violations of California civil code. So it looks like the one is a Consumer Protection Act violation, and the other is related to an unfair competition claim. And then the last is civil conspiracy. So I guess now that I've kind of given that high level, what's that?
Yeah, I have a question about it, because like you were saying, these 9 different complaints are they're kind of recipes, and the point is to, I guess, decide if the ingredients are all in place to say, yes, this is what we've got here. This is the final product. So if they'll try to argue all 9, but the church could be found either guilty or not guilty on each of these individually. Is that correct?
Yeah. So let me start.
It's not a package deal.
That's right. So let me start kind of at the last one. So in a civil case, I think it's probably important we understand that there's really no guilt. Guilt is really like guilt is a criminal term, right? So it's liable or not liable, but it's the same basic idea. Like, will the church ultimately have to pay back damages for these violations of civil law? We just tend to use different terminology when we're talking about civil lawsuits. Liable versus, guilty. I think the big difference is that guilty, a lot of times when someone's found guilty, right, they at least have the possibility of doing jail time. Whereas in a civil complaint, that's not even a possibility. So, but you're right. Each of these claims, and I appreciate your question, because each of these claims do stand on their own. So it is entirely possible for the church to be found liable for one or more of these different theories or different causes of action, and in fact to not be liable on others. And in fact, there's actually a legal concept that people may find interesting, which is that a lot of times, especially during the complaint stage, the early stage of litigation, a complaint may articulate several different theories in the alternative. So that's the magic word there, in the alternative. What that means is that, I might sue, someone for some action, and I may have several different theories on why what they did wasn't okay, but they might be mutually exclusive. So I might be suing someone for trespass, unjust enrichment, nuisance, all of these different things. But in some instances, you can only pick one of those different things. Like the defendant can only have done one. And so that's why we use this legal term, like in the alternative. And so I don't remember off the top of my head if any of these theories are in the alternative. Probably not, but I think it's also important people understand that like the complaint stage where this lawsuit is at right now, and it also has to go through the class certification process, which I know that you had Dr. Randy Bell on to talk about, which is great. I actually just talked to him this morning. I love Randy. So anyways, I guess my point is the complaint is the starting point. There's a whole lot that has to happen between complaint and trial, and that's only complicated by the fact that this is a class action. There's a lot more. There's a lot more steps, basically procedurally, that has to happen for.
That's what my main takeaway from the interview with Randy is that it's just really early on, and really not a lot can be said or known. There's just a lot of ifs ahead and a lot of time. So, yeah. So I appreciate you coming on at this point to at least go over this part, and we'll keep updating as the case proceeds. So
sure.
Yeah, thank you.
Yeah, and so let's really quickly go through these 9 different theories of the case. I'm not going to go through the elements like in depth like we did kind of even at a high level on negligence. I'll just kind of talk in general lay person talk about what each of these things means. So fraudulent misrepresentation, the first cause of action, that is the idea, and this is the premise of John Huntsman's lawsuit as well. That's the idea that the church, in soliciting tithing donations, misrepresented material facts to people to induce those donations. So when I use the word induce, what I mean is that they were the cause of people donating. So I know specifically in the James Huntsman lawsuit, it draws attention to statements that President Hinckley made, drawing this distinction that was never disclosed to the public about the difference between tithing funds and invested tithing reserve funds. And so the argument from the plaintiffs in this complaint is that amounts to fraudulent misrepresentation, essentially that it misrepresented the facts to such a level that it's a violation of the law, and that the plaintiff should have those donations returned to them. Any questions on that cause of action, Maven?
No, I guess I just want to make it clearer that when you pay tithing, or at least at certain points, I know the church updates its tithing slip, but I know that when I was a tithe payer, there were, besides tithing, there were also other things that you could donate to. And my understanding is that there's no actual guarantee if you're wanting to donate maybe to a missionary or to a Book of Mormon fund or something like that, that the money that you were paying into a specific cause was actually going to that. And the same with tithing. I know members of the church, you could still see this whenever these things come up. Faithful members in the comments under any posts about this stuff will say the things that we were taught to believe about tithing, which is that it goes to running the church, that it goes to expenses really for members, for wards, for activities, for the youth, for building maintenance, for all these things. And while it may go to some of that, the fact that the majority of it is just being hoarded and massed up and is used for a lot of things that members of the church don't even know the church has anything to do with, like land deals, other just business ventures. There's so many that we just don't even know about that money is going to, including for-profit ventures, rather than us and the building up of what we thought or think is the kingdom of God on the earth today. So that's I guess that's my contribution to that one. And that's the main complaint, which is why it's number one. And then the main problem with the way the church induces, as you would say, or encourages its members to give them money. It's under this idea that we're helping out, we're helping each other, we're helping the church, not that we're helping the church buy land and properties and things like that don't serve us, that we can't even use.
Yeah, that's exactly right. And I think that's basically the theory on this first cause of action, is that that the church's behavior over soliciting the donations and the statements it's made about how it uses funds have been so misleading that they've crossed that legal line that is not permissible. I do think one thing I would note, since you mentioned the tithing slips and the changes in the tithing slips, the church changed the tithing slips, I think about a decade ago, maybe slightly more, early 2000s or early 2010s. And oftentimes when, lawsuits like this are discussed with believing members. There are times I see people say things like, well, the church like puts right at the bottom that they're going to do whatever they want with this money and it becomes their property. I think people need to understand that like just because they put that at the bottom doesn't mean that it's okay that they really do whatever they want with the money. Like that disclaimer may protect the church in some way, but it doesn't entirely protect the church. That doesn't mean that you can, just because, I guess what I'm saying is just because you put the appropriate disclaimer on there doesn't mean that you're absolutely protected from any liability connected to that behavior. It's just a really weird argument I see a lot of times. And it's important that people understand, like, we don't live in that reality anymore. Like our system, and I've used this phrase a few times, and I probably should have explained it earlier. Like our system, the American system of law, with the exception of the state of Louisiana, because they're weird and unique, but that's okay. Our entire American system of law is premised off of English common law. And English common law developed over time. And the idea, and I've used this phrase common law that I should have explained earlier. All that means is that judges, when they hear cases and they decide cases and they decide, yes, on these facts, that was a fraudulent misrepresentation. I'll just use that as an example, right? The common law system means that over time, what has happened in previous cases adds to our understanding for future cases. The fancy Latin word that sometimes you'll hear thrown around in legal circles is stare decisis, which just means let the decision stand, which means that judges base their decisions off of the decisions that have come before, that we want to have predictability in this system. That's the entire idea behind the common law system that forms, at least in part, the basis of our American legal system. And I think it's important that people understand that idea of like, well, people can do whatever they want to you as long as they have the appropriate disclaimers, that has been disfavored since the early 20th century, really, when we had the New Deal.
Because then anybody, any charity could just put that on and just say like, fundraise for this family or fundraise for this thing that they know their constituents will really care about. And if they could all do it that way, then basically everyone could just put that disclaimer and then use the money however. It just would be and unreliable. So no, that's a good point. And I know as a believer, when I read that, I always just thought like, I still thought the money is going to the things that I believe in, but maybe if some came from this, Book of Mormon fund to the mission fund or something, like if there's a little bit of crossover, that was what that meant to me as something, that I know now on this side of things, the broader scope of where that actual money is going. I don't think I would have felt good about that or about my money going to that. I was donating because I really thought my money was going to help other people, like actual people, not acquiring land or, lawsuits and things like that. So thanks for clarifying that.
No, yeah.
Should we go on to number 2 or?
Let's move on to number 2. So number 2 is very similar to the first one, but fraudulent concealment. The word conceal, I think we all kind of know commonly what that means. It's basically the idea that the church was hiding these things for the purpose of inducing these donations. And I haven't reviewed that specific factual section too closely, but I'm guessing that this is premised off of certain statements that Roger Clark made and directors from Ensign Peak made after David Nielsen's whistleblower report came to light in late 2019. That's probably the basis of this theory in the complaint, which is basically the idea that the church purposefully held these things back from the membership to continue inducing the donations. It's very related to the misrepresentation claim. They probably go hand in hand largely. Any questions on that?
Nah.
Cool. So the negligent misrepresentation and then the negligence, we really talked about the misrepresentation piece when we talked about the first claim. So let me talk briefly about the difference between negligence and fraudulent, between basically the difference between this first and this third claim. So negligence is a legal concept that basically imposes liability on someone for not behaving as a reasonable person would. So I went through those 4 different elements that you typically see in a negligence claim. You've got your duty, breach, causation, and damage. The difference between negligence and fraudulence, which is this difference between the first and third causes of action here, is intent. So when someone has a fraudulent intent, And it's important to note that fraud is very difficult to prove in legal cases. It basically requires the plaintiff to show that the defendants knew that the statements that they were making were completely fabricated at the time they were making them. Basically, it can't have ever been, if we're talking about fraud, it can't have ever been just a mistake, whereas negligence can be just a mistake. So negligence can be a theory on, a car crash case where the person may not have intended to hurt you, but they breached some duty that they owed to you to act as a reasonable person would. And so to bring this full circle, the difference between the first cause of action here, fraudulent misrepresentation, and the third one, negligent misrepresentation, and then the fourth, negligence, is really just the intent. This is basically a less demanding claim to prove than the fraudulent misrepresentation and the fraudulent concealment would be. And so it's going to be premised a lot less on what the church said, any potential misrepresentations they made, and be more about the effects, basically, like what came out of the church's designed scheme.
So I see it as the difference between men in a meeting room kind of like twirling their mustaches and mahaha that they're doing this, versus maybe when they said or asked for things, and especially with the church, because there's so many different leaders. So and we've got past prophets and apostles that have encouraged donations and said why we do them, and that's why members continue to give, whereas now, years or decades later, different people are in these committees that are handling this money, and so maybe they make different decisions, whereas again, like that, I guess that's the negligent part, or one way that this could happen, where again, the intent between the messaging that we get versus who's doing what is just human error, basically.
Yeah, I think
again,
that's
versus the cartoonish villain, like doing it on purpose, stroking a cat in the background kind of a thing.
Yeah, which is not to say that sometimes legally you can't have cases where someone honestly did not intend results that then amount to fraud or cross the line to like an intentional tort, which is over and beyond negligence. But oftentimes those cases are someone who's so incompetent that it's like you can't tell the difference between incompetence and intentional bad action. I don't, and we may see some of that play out in this case as it continues, frankly. So it's interesting.
Okay.
These theories, I think what I'm really trying to explain is the fraud and then the negligent misrepresentation. Those are probably like alternative theories, because the negligent misrepresentation theory requires less of a showing of bad intent and probably even less intentional misrepresentation than the first claim does, which is actual fraud.
Got it. Okay.
So our fifth claim, breach of fiduciary duty. So fiduciary duties arise in different types of contexts where someone is supposed to be acting on behalf of someone else. So the classic example I can think of is myself as an attorney. Anytime I work with clients, I have a very specific duty that in some contexts can arise to a fiduciary duty to look out for their interests at the expense of my own interest, including that far. Other cases where we see fiduciary duties arise are like if someone is the administrator of an estate, or they are they're administering a trust. They are going to be acting in a fiduciary capacity, which means they are acting in the interest of someone else. And so breach of fiduciary duty is a cause of action that happens when that actor that's supposed to be looking out for someone else's interest doesn't, and they basically breach that and use it to their own advantage. And so at a high level, the theory behind this claim is basically that the church owed the plaintiffs a fiduciary duty by accepting these donations, kind of part and parcel with what you were saying earlier, Maven, about, I donated because I felt like this is what I would be doing. I was kind of in the same boat. And so the plaintiffs here would be arguing that the church, by accepting those donations in that context, created this fiduciary duty to look out for this money and do the right thing with this money that the plaintiffs thought the money was going to be going to, and that it didn't do that. And so that it breached that duty.
It makes sense. The only thing I know of about fiduciary duty, and I just said that weirdly, but anyway, is like within personal finance, that if you're going to
Right.
have somebody who's going to be managing or advising you, you really want to have someone that owes you this fiduciary duty, um,
Mhm.
because not everyone does, but someone who does have this legal obligation is legally required to have your best financial interests in mind,
Right.
versus a salesman for some other, maybe a company and their products, who does not have that duty to you. So that's what I assume, or that's the knowledge that I took to that. So yeah.
Yep, that's exactly right. And basically, the theory is when they break that, if they put their own interest above the person to whom they owe the fiduciary duty, the court can make them pay it back or hold them liable for the damage that they cause. Unjust enrichment, we'll talk about really briefly. Unjust enrichment is a claim you see often that goes part and parcel with like breach of contract. Obviously, there's no written contract or oral contract that goes along with tithing donations. And so unjust enrichment is very much a claim that is trying to get money back from someone on the basis that if they were to keep the money, that it amounts to unjust enrichment. And so the idea is, the reason you see it in a lot of contract cases is like, well, we had this dispute over this contract, but I paid this person a certain amount, and so I expected them to do something. That expectation was reasonable, and so if they don't do it or they don't pay me back, that amounts to unjust enrichment. And so this is, I don't want to say it's similar to the breach of fiduciary duty claim, but it's a similar argument in the sense that it's premised on the reasonable expectations of the plaintiffs, basically saying that the church holding on to this money under the circumstances would be unjust. And so that's the theory there. So I'm not going to opine on California law, but I'll just really quickly talk about, earlier we just a second ago talked about, the shift in the common law happened, and we do have consumer protection acts. We do have laws that protect against unfair competition or unfair business practices. And we were talking about this specifically in regard to like disclaimers. How far can a disclaimer get you? All I want to note, since I don't practice in California, is that, as far as I know, every jurisdiction has a consumer protection act or has protection against unfair business competition. And so for people who want to pivot to like try and make the church look better and say like, well, they have this disclaimer in place, I think it's important to note that like that's not the way our legal system has worked for a very long time, since we had standard consumer protection acts or standard protections against unfair business practices or unfair competition practices. And so this really just highlights what I was talking about a few minutes ago, that you can see the way that this has shifted. We basically don't have this. The doctrine, the legal doctrine that came out of the English common law was known as caveat emptor, which is the reason that lawyers use so much Latin is just so that we can charge you so much when you have to come talk to us, because we get to explain what the fancy terms mean. But what caveat emptor
Buyer
means is
beware.
it means buyer beware. That's exactly right. And it was premised off of, the 15th, 16th century, like town square, like going and having a town square where you could exchange with people. And all I want to highlight on claims 7 and 8 is just, you can see very clearly that California, along with every other state, protects consumers to a greater level than caveat emptor ever did. So it's always weird to me when people then pivot as if caveat emptor is still the law of the land. Like, it just isn't. Sorry, we have regulations that protect food. We have regulations that protect medicine. We have regulations that protect consumers because we need them. That's one of the things
Yeah,
I
I
guess
think.
I'd highlight. Oh, go ahead, and then I'll finish
Oh,
with
yeah,
my
no,
thought.
I was gonna say, because I know people who kind of think this way, where it's like, look, if you're stupid enough to get conned by somebody, then, that's on you. And I guess to a degree, there's some personal responsibility. But if you took that, and where anything that I ever pay for, or any person I trust, the full burden is on me to do who knows how much of, like, massive amounts of research behind every company, behind every person who's
Mhm.
telling me about a product or selling me something. It's literally impossible to do. So we need these things. We need to, for society to function, I think we need to have a baseline level of trust, that when we are making purchases, or getting things like licenses to drive, that there's just a basic expectation that we can come to something with. Otherwise, it's just chaos, because nobody could really do the due diligence on everything that our lives, like our lives, are involved with. So
Right.
that
I
that
mean,
was my idea on that.
that's the entire reason I would argue we have government in the first place, is because we can't do all of this stuff, and we do need some bare minimum standards that companies have to operate by. And it has been a big shift, like even over the last 100 years of American jurisprudence. I think one of the things I would just point out in support of things like Consumer Protection Acts is one of the things that we've learned is, and it's not completely the fault of companies. Part of it is the legal structures and incentives that we've set up. But the bottom line is there are far too many cases that highlight that private businesses will prioritize their own profits and their own interest, literally to the extent of allowing people to die that did not have to die. There's a famous case involving the Ford Motor Company and the Ford Pinto that everybody who goes to law school, you have to cover it and learn about it, where basically the Ford Motor Company knew that there were defects with one of their vehicles that if they were hit from behind, it would cause like a fiery explosion, trapping the people inside and letting them die. And because they're a business and we didn't have as strong of protections for consumers, the Ford Motor Company decided that it would be cheaper to pay out and settle potential lawsuits from people who died than to go through and make this like minor correction to this gas tank that I think would have cost, it was something ridiculously low, like $7 or $17 a car to fix. But they were just like, well, it's a dollars and cents game. There's this many of these cars. It'll cost us this much. We think it'll cost us this much in settlement. And that's one of the reasons that we have courts in the first place, is to send the message that weighing human life like that is not okay. And it's one of the things that we have enshrined in statutes like Consumer Protection Acts, like these things. And so I agree with you. People who go to this far, almost like anarcho-libertarian bent of, well, whatever's going to happen, caveat emptor. It's like, we haven't lived in that for at least a century. We haven't lived in that reality for a century. And I agree with you. I think it's entirely unreasonable to think that we could live in a world like that.
Yeah. I think one example, I know we're kind of going off the rails here, but is the vitamin industry in the United States. From my understanding, is they lobbied very, very hard, early on in the game, kind of under this thing of not wanting too much government interference. It's the same thing I think the food companies and drug companies will do sometimes, which is just it kind of put this idea out to the masses that it's a bad thing for the government to put regulations on things. And with what I understand from the vitamin industry is that it's so out of control that a lot of times you can go to a store and buy a particular vitamin supplement, and under testing, it has either shown to have very harmful things in it, and sometimes not even the vitamin, or not very much of the vitamin that you're actually trying to get. And that's a frustration that I have, is that because there's so many out there, and I know that this is such a huge problem, I wish I could trust that if I'm buying vitamin D supplements, that I'm actually getting a significant increase of vitamin D from it. And since I can't know that, that's something that's frustrating to me. So hopefully that's something that comes around. Anyway, that was just one example. We can move on to number 9, I think.
Yeah. Before we cover the last, just because I like your example. There's this great Tim. I don't know if you're familiar with the Australian comedian and songwriter. He's hilarious, Tim Minchin, but he has this great song where he does a poem called Storm. And what you were talking about reminds me of this great line from that song where he's having a conversation with this very new agey, very loose, truth is a loose weave individual. And he makes this joke and he says, alternative, do you know what they call alternative medicine that's been proved to work? Medicine. And anyways, I'll just leave it at that. Okay. So our last claim, civil conspiracy. So we talked about the difference between civil and criminal law when we kind of talked about the use of the word guilty versus liable. In most contexts, a conspiracy is an agreement to violate, whether it's a criminal or a civil statute. It's an agreement between two or more parties to violate the law and to then take some act to that violation of law. That's usually what's required to demonstrate a conspiracy. And so the idea is that conspiracy is its own separate liability for that actual agreement and for basically working with other people to do something that violates the law. It's civil in this context because there are no violations of criminal law that have been alleged. Individuals, for the most part, can't allege violations of criminal law anyways. That's something that the state, through prosecutors' offices or district attorneys, pursue. But that's the basic idea here, is that there was some agreement that happened. There was some planning, some scheme that created this entire situation, and that itself is actionable in the minds of the plaintiffs.
I'm trying to think if there's something in what I know about the recent cases, around Ensign Peak, that this falls under. I guess I don't have it off the top of my head, but I feel like we are aware of conversations, or at least that the brethren, the top three, the prophet of the church and his counselors, were advised in certain cases about that what they were doing was illegal or would be, or I don't
Right.
know. Is that where this comes in, or
Yeah,
do
and
we
so
have statements to back
I
this?
I probably should have brought up the SEC order from last February earlier than now, but I think, because I do remember that's a big part of the complaint, the plaintiffs pointing to that violation of reporting, a provision of securities reporting law. That I think is essentially right, Maven. That's a big part of this, is basically that. And I believe I did the episode with Nemo doing kind of a deeper dive on the actual SEC order last year. So that might be a good thing for people to refer to, because I don't have all that off the top of my head from a year ago. But there were points in that order, which is a joint stipulated order that the church had to agree to and Ensign Peak had to agree to, that makes very clear in that order that the senior church leadership was aware of and approved the creation of shell companies to hide the size of the church's asset portfolio. And so that would be probably part of this allegation for the civil conspiracy. Yes.
Got it. Okay. Thank you for clarifying that for me. That's where my mind was going, but then I wasn't sure.
Yep.
But yeah. Okay. So I think that's it. We mean for this episode to be a shorter one. And yeah, I think we've hit all the points, and hopefully this makes it really easy for anyone to understand, I guess, the basis of what is going out there, and hopefully we can see some results from it. Or at least
Yeah.
I would hope a change in the way the church operates, to at least start to be more honest and forthright, or not. I guess we'll see.
Right. No, I completely agree with you. I'm going to follow this closely. I've been following Huntsman's lawsuit since I first learned about it, so I'll continue following that one as well. It is interesting that we're seeing, I think this is the third of these types of lawsuits, and so we're seeing more and more people that are attempting to hold the church accountable for statements that it made about how it used tithing, and I think that's entirely fair, and we'll see how the courts adjudicate it. On the one end, we have the First Amendment, which is a giant protection for religion in the United States specifically. But in Huntsman's lawsuit, that has been basically recognized as not being implicated by the claims. And that's one of the reasons, one of the mistakes, in my opinion, in the litigation that happened in the UK involving Tom Phillips trying to make similar claims, is that lawsuit got too into the weeds of the church's theological claims. And so these lawsuits are very wisely looking just at this, basically at the treating the church like anything else. Like, they solicited money from me in this context. They said this wasn't true. And so they should be held accountable. And I think that's wise, because it steers clear of the First Amendment's protections.
Perfect. Thank you so much for coming on, Kolby, and explaining all of those things. And I mean, just like you said, you'll be tracking this. Obviously, we will be too. And Latter Daily Digest will be updating when there are updates on this, which, again, as Randy pointed out, may be over several years. So thank
Almost
you.
certainly.
Yeah.
Almost certainly.
Yeah.
I mean, I had filed a complaint just late last year, just so people understand kind of the timeline involved. I filed a complaint late last year on a case I was working for a client. And just yesterday, I got the scheduling order from the judge, and we're looking at trial dates in mid to late 2025. So we're right now in the
Wow.
beginning of 2024. We filed this complaint in late 2023, and the soonest we can see the inside of a courtroom for trial is mid 2025, like May 2025. So that's how long the typical like case takes. And this is just like a simple state law case. This isn't a federal court case like this one is. And so, yeah, the legal system takes a lot of time. I would guess we'll see some type of serious decision on this within the next 5 years. So that's where
All
we're
right.
at.
And maybe we'll have you back on for that. I hope so. Thanks again, Kolby, and thanks again to our audience. Remember to like and subscribe if you want to be seeing more content like this. And then the episodes and things that we've referred to we'll have in the show notes, hopefully by premiere. So again, thank you everybody for your support, and thanks, Kolby, for coming on.
Thank you. Can I take 1 second to say how much I
Yeah.
love that you're working on this show, and how much I appreciate your perspective and voice in this space, because you specifically, I think, do a lot for this community, and I'm really, really grateful for all that you do and that you invited me on. So thank you.
Thank you, Kolby. I appreciate that.